Hello, everyone. I'm Steven Svoboda. I'm sad to report that my friend and colleague Rob Darby has passed away. Rob was a good friend. We worked together on a couple papers, both called The Rose by Any Other Name. He wrote a very magisterial comment to the Tasmania Law Reform Commission. He had a great sense of humor, a piercing intellect, and he's with us no longer. Rest in peace, Rob. In 2001, the nonprofit organization I founded in 1997, Attorneys for the Rights of the Child, organized a team that went to the United Nations Subcommission for the Promotion and Protection of Human Rights in Geneva. That's a subcommission of the Committee for the Rights of the Child, the CRC, which we'll be talking about more. On August 9th, 2001, I presented a written intervention, as they call it, to the subcommission, and on August 14th, I presented an oral intervention, a written version of the same presentation. Both of those documents became part of the official UN record, and in theory, anyway, were considered by every member of the subcommission, every subcommissioner. Now, whether every person actually read it and considered it, we don't know, but that's the theory anyway. Present in the audience, along with the subcommissioners, were members of government missions, representatives of intergovernmental organizations, NGOs, and credentialed observers. While a wide range of protections had, of course, been installed by the UN to protect against female genital cutting, no action had been taken at that time whatsoever regarding male genital cutting. In those days, human rights research at the UN involved going down in the dark, dank basement and making photocopies. Anybody remember those? So I had a stack of paper in my room in Geneva about 4 feet high. I also had a picture of my son, who's now 17. It was his very first ultrasound at 6 weeks after, no, sorry, not 6 weeks, 3 months after creation. Anyway, so my research down in the bowels of the UN turned up a very surprising fact that this office of the subcommission that was formerly called, the Special Rapporteur that was formerly called Special Rapporteur to protect the rights of women and children. Now, one could query why men aren't included in that, but leaving that question aside, the women and children got changed to women and the girl child. And the thing that was very shocking for me, a then very naive 37-year-old person just 6 years out of law school, very naive and expecting the world to work as it's meant to work, they didn't do it properly. They didn't institute it formally. They never announced, oh, we're changing our name because of these reasons. It was just done at dark, as it were, at midnight. They went up and, as it were, they changed the letters on the sign without telling anyone. I couldn't believe it. Had to check and recheck my research to actually believe that was actually true. So oral interventions by organizations such as the one I gave are limited to 1,500 words, quite short. In our intervention, we mentioned domestic and international violations of equal protection. Equal protection of males and females is obviously violated by male circumcision. We talked about that yesterday relative to female circumcision. We talked about the UN Charter, the Declaration of Human Rights, the Covenant on Civil and Political Rights, the Covenant on Economic, Social, and Cultural Rights, and of course the Convention on the Rights of the Child. I suggested to the UN that, quote, the best way to do justice to the rights of the child is to do no harm, to let it enjoy life in every aspect and to protect it and love it. When the child is of the age of consent, he or she can make up his or her own mind about his or her own body. We asked for 2 actions from the subcommission. One, reversing this change in names that happened so that the mandate of the Special Rapporteur could go back to covering male children. We didn't mention anything about male adults. Presumably they are protected by human rights, I'm not sure, but we left that out. Second, we asked the subcommission undertake a study of MGC, male genital cutting, as a human rights issue. And that did in fact happen many years later, as we'll hear. So these 2 actions were specifically designed to be attainable, at least possibly attainable. We cited the appropriate documents, Universal Declaration, talked about equal protection. And then our next phase sort of was we arranged personal meetings with the subcommissioners, 26 or something like that, subcommissioners. And we had quite a lot of success at first at meeting with them. They were quite amiable. We had nice conversations. They seemed very interested. No one really seemed able to do anything or work with us, but we didn't really expect them to. They had their own issues. That was fair enough. But as time went on, a very interesting thing happened. we'd go to a meeting that was arranged and no one would be there. And at first we thought, okay, we got the time wrong. This is back in the days of paper date books, of course. We've messed up, or maybe they messed up or something. It kept happening though, 2, 3, 4 times. We went to these meetings. They didn't send us an email. They didn't give us a call. So clearly they were talking to each other. They were finding out what our issue was and deciding not to participate, which is contrary to their mandate, in fact. So when the experts, as they're also called, the subcommissioners that we met with, there were a few. We did talk about how, as discussed yesterday, some forms of male cutting can be worse than some forms of female cutting. And regardless of that point, that all human beings are entitled to protection of their basic human rights. That's what human rights are. And one influential subcommission member even reported talking about male circumcision as a human rights violation in a textbook he had written. So that was interesting. Some subcommissioners would disingenuously, in my view, claim lack of power to do anything. Well, isn't that your role? I mean, aren't you one of 26 on the subcommission? But that was what they said. They were receptive, and I don't mean to sound facetious. They were receptive. I do sincerely appreciate it. I mean, they did listen to it, and it probably was pretty weird from their point of view. They'd never heard of it before. Seemed odd. They treated us with respect, and we appreciated that. We got a bit less respect from this special rapporteur herself on traditional practices affecting the health of women and the girl child. That was Halima Mbarak Warzazi from Morocco, and she's a Muslim, and she was quite hostile. She wouldn't meet with us at first at all. Then we sort of insisted on it, managed to get a meeting, and she sort of sat there like, very closed, body language, and scowling at us, and mentioned Judaism. And we said, oh, well, actually, we're glad you raised that because one of our team members is in fact Jewish. Would you like to talk with her about this issue? I'm sure she'd be quite interested in engaging in discussion with you. Well, probably guess what her answer to that was. So it sort of went on like that, and Mrs. Warzazi eventually said, somewhat surprisingly, that it would violate her Islamic faith even to talk about our issue with her. So let that sink in for a minute. She's employed by the UN. She's the only special rapporteur on traditional practices affecting the health of women and the girl child. It would violate her religion to do her job. I mean, it boggles the mind, really. It boggles the mind. So we didn't go to Geneva expecting that the UN would instantly sort of do an about-face. We weren't sure exactly what the future course would be. We sort of hoped that sometime in the future there would be a continuation of these efforts. We didn't have the resources to do follow-up visits at that point in time. So for a decade, more or less, as far as we know, nothing happened with the UN and male genital cutting. And that brings us to Antony.
Thanks, Stephen. So the National Secular Society here in the UK, with which the Secular Medical Forum, which I chair, merged 2 years ago, is a member of the International Humanist and Ethical Union, IHU, which is an NGO with special consultative status at the UN. On the 17th of September 2012, a few months after the Cologne ruling, the following short statement was read out by an IHU representative in the 21st session of the UN Human Rights Council, and this was supported by SMF input. Madam President, the recent German Cologne district ruling outlawing non-therapeutic infant male circumcision correctly places the welfare and the fundamental rights and freedoms of vulnerable children above the unrestrained expression of adult beliefs. The court correctly determined that non-therapeutic cutting of a child's body is an assault, that children are unable to give informed consent, that surrogate parental consent is not valid for an operation with no clinical indication and with the potential to cause serious harm, and that children have a right to be protected from bodily harm. Such determinations cannot legitimately be overridden by adults convinced that children might be harmed by denying them this forced, irreversible surgery to their most intimate body parts. When the children become adults, they can freely decide whether or not to undergo the procedure. We understand and have some sympathy with the sensitivities of certain religious groups which may feel threatened or even attacked by the judgment, particularly in the light of recent history. But it would be wrong to describe this judgment as religious persecution or anti-Semitic. Some Jewish voices are calling for an end to the practice, and there's even an association called Jews Against Circumcision. Powerful groups must not be permitted to impose their views on the vulnerable on ideological or theological grounds in contravention of international law. The Royal Dutch Medical Association and 7 other Dutch scientific associations concluded in 2010 that the procedure can be harmful and that it violates the boy's human rights to autonomy and physical integrity. The German judgment is therefore both laudable and overdue. Reflecting as it does states' obligations under the International Covenant on Civil and Political Rights, it should be followed by all member states. Our written statement on this issue is available. Thank you, Madam. That was the statement read out. IHU also wrote to the UN Committee on the Rights of the Child, which resulted in a surprisingly swift invitation to meet the chair of the UN Committee on the Rights of the Child. On the 4th of October 2012, I had the honour of leading the 3-person delegation where we met the chair, the vice chair and the acting secretary. Unknowingly, at an informal lunch meeting, we also met the future chair. We were received cordially by the then chair of the Children's Rights Committee, Monsieur Zermatten. And I opened the meeting by explaining how my work as a GP with child protection responsibilities, I was at the time the county GP representative on the statutory local safeguarding children's board, along with my secular medical forum interests, had led to a consideration of the issue. I discussed how the basic medical ethic that a child not yet old enough to consent should only be operated on when there's a pressing therapeutic reason is exceptionally broken in this case. And I suggested that this was more of a human rights issue than a medical one. Monsieur Zermatten, describing himself as a Catholic, said that it was a very sensitive matter because of the involvement of religion and the general lack of knowledge. He indicated that it had already been discussed by the Committee on the Rights of the Child briefly and was due to be done so again the following week. He referred to recent decisions in Finland and the European Court finding against the practice as injurious to health, and noted the committee's previous statement on South Africa, where harm had been caused by traditional, crude, non-sterile circumcision operations. He mentioned, though, the purported health benefits, and he expressed strong interest in the medical evidence. So I drew attention to the known harms and the recently available evidence from the UK, including the 11 babies admitted to paediatric intensive care in Birmingham as a direct result of circumcision treated in 1 year, and also mentioned some recent deaths. The Vice Chair, Professor of Law Hatem Kotrani from Tunisia, raised 2 main objections: religious rights and the perceived importance of operating at a young age. He said he'd done so to his own son. And in acknowledging the importance of the right to freedom of religious expression, I suggested that the child's right to freedom of religious expression should be the focus for an operation performed on a child, not an adult's right. I also questioned the assertion about the benefits of early surgery. Babies can't complain, and parents are unlikely to, even if they know of the problems. I shared information about the increasing dissent from within religious communities themselves and the statements from medical associations against the practice. Professor Kotrani emphasised his commitment to human rights, which I don't doubt. And Roy Brown, former president of IHU and main IHU representative at the UN who was with us, stressed the importance of ensuring individual rights were not subsumed by group religious rights. Afterwards, the acting secretary helpfully provided us with some information as to how to input the work of the committee most effectively by submitting short reports with clear recommendations to the committee in advance of the consideration of each nation's compliance with the convention. During each of 3 or 4 sessions a year, about 4 or 5 nations are considered on a rolling, roughly 5-year review of compliance. By coincidence, Israel was coming up for review the following year, and the SMF supported the Israeli organisation Ben Shalem to submit a brief report alongside our own. We made several recommendations, including the requirement for a medical need, a central registry, clear documentation, and active steps to monitor short and long-term complications. And we had a result. For the first time ever, in July 2013, the UN Committee on the Rights of the Child concluding observations on Israel's compliance with the convention included male circumcision in the category harmful practice, and recommended that Israel undertake a study on the short and long-term complications of male circumcision. So it's evident that the committee cares deeply about children's welfare. We learned that they welcome short third-party reports with evidence, and that these have the potential to influence the committee's determinations, and they're particularly keen to hear from organisations within member states. it was also apparent that religious sensitivities play a large role in the reluctance of many organisations to take the necessary steps to protect all children from forced genital cutting. And the committee can only take action if supported to do so by relevant evidence provided to them in a form they could use. So 3 years ago, in 2016, a handful of us from across the globe, including Stephen and I, began to participate in an international project with the intention to provide regular, short, supplementary reports to the committee from each nation as they come up for periodic review, and to prepare for the review of Israel, which still has not yet been scheduled. We met regularly by Skype at unsocial hours for most of us, inevitable due to the time differences, 6:30 in the morning for me. Our objectives and strategy evolved over time. With so much available supportive evidence and information, we had to learn to be selective. The more we learned, the more questions we had. Would it be better to submit a comprehensive document? Should we ask for a meeting with the committee to discuss this? Perhaps, but some advice we got suggested that committee members were becoming tired of axe-grinding single-issue activists when they were regularly dealing with child soldiers, child prostitution, murder, starvation, etc. Would it be useful to ask the committee to form a general comment on non-therapeutic genital cutting, as they've previously done on topics such as corporal punishment? A general comment provides a basis for the committee to explore the topic with every nation during each periodic review. Our aim was and remains to be an authoritative source of information to the committee and to engage with national intactivist advocacy organisations and to support them to submit evidence to the committee alongside our core document as each nation comes up for review. We were supported by the gateway NGO to the committee, which is Child Rights Connect, and by CRIN, Child Rights International Network, whose CEO, Veronica, very kindly joined us for one of the Skype meetings. We gained some understanding as to the complexity of the process and how dependent our success or otherwise might be on constituent members of the committee, and that there isn't just one right way of doing things. Paul Mason was a driving force behind the document, a very dear friend and a wise head who placed us squarely not as activists but advocates for children. And when he died suddenly last August, it was a huge loss, both personally and professionally. We named ourselves INGOCGA. Slips off the tongue, doesn't it? International NGO Council on Genital Autonomy, after other NGOs which had submitted similar documents to the UN. There were inevitably some internal INGOCGA discussions on style, content and volume. Generally, we felt that less is more. We voted down suggestions to include distressing images of children in our document. And after nearly 2 years of discussion and debate, a core group of 4 of us agreed on a final draft document just over a year ago in 2018, subtitled "The Cutting is the Harm," which addressed all relevant angles and called on the committee to formulate a general comment calling for the eradication of all forms of genital cutting of children, non-therapeutic. And the draft was agreed by all 8 members. Within the document, we introduced the acronym CGM/C after the parallel description of FGM/C, which appears in the committee's documentation. And we described the appropriate standard for evaluating medically unnecessary surgeries as benefit versus risk of harm, not benefit versus risk of surgical complications, which we also cited estimates of roughly 13 to 65 million males with complications worldwide. Once the draft was complete, it was sent both to Child Rights Connect and to CRIN for their consideration and advice. We needed a lot of help as to how best to use it. And the response from Child Rights Connect was unexpected and rapidly took us in a new direction. Ilaria Paolazzi from Child Rights Connect emailed me back almost immediately, suggesting that INGOCGA might find a foothold at the committee by offering a third-party submission to an ongoing Committee on the Rights of the Child case from Finland. And Paul and Stephen agreed to lead with this process.
Hello again. So in July 2018, INGOCGA modified the core report to create a report on circumcision as a human rights violation in Canada that we submitted to the UN. And following Paul's sad demise, Antony and I took over to lead preparation and submission of a third-party intervention. Now, a third-party intervention is a relatively novel procedure. If anyone knows what a friend of the court or amicus curiae brief is in the US, it's a similar concept. A third-party intervention advises the Committee on the Rights of the Child. We're not a party in the case. We're advising them. You could say as an expert or something akin to an expert. So due to the kind collaboration of these organizations that Antony mentioned, they helped us sort of along the way, and we were, in the end, able to obtain an invitation from the Committee on the Rights of the Child to submit a third-party intervention to advise it regarding the anatomical, medical, human rights, legal, and ethical implications of male circumcision. And the specific case that this was related to was a 2016 Finnish Supreme Court case that had found a doctor and father both liable for a circumcision of a 4-month-old boy. So a number of practical issues presented themselves. I mean, the first one was we didn't bloody know what the heck we were doing, so that was the first one. And I mean that in all seriousness. We made it up as we went along in the grand tradition of lawyers throughout history. First, we needed to get the formal permission to apply, which we did with the help of these cooperating organizations. We cited the prior work we had done, Antony's work and my work that I talked about earlier with our UN team. And we stated our purpose in intervening is to provide information regarding law, regarding the procedure, including applicable domestic and international human rights cases, impacts including psychological impacts, medical impacts, non-medical impacts, and other information that's relevant. We appreciate the topic is perhaps a delicate one, and we will address it with appropriate sensitivity, and there's a little more to say about that later. Naturally, our third-party intervention would constitute a recommendation based on our expertise, since we're not representing a party. Our aim was to be of help, and we took that quite seriously, and our request was actually quite quickly approved. The first hurdle to writing a meaningful document was getting the pertinent documents from the Finnish case. Now, you might think that would be easy. You would be incorrect in that. The person that worked on the case, astonishingly enough, was not in fact a lawyer. It's a woman who I think was perhaps studying for a master's in law or something along those lines, and she was on maternity leave, which you wouldn't think would be an issue in this day and age, but apparently she read her email about once a month. So it actually took quite a lot of work and phone calls to Finland. I have a Finnish friend through my music fandom, and he rung her up, and eventually we managed to get the documents. It wasn't easy. Then we had the practical question of timing, because we had an initial deadline of the end of October last year, and by the time I got the documents, it was sort of 5 days before the deadline. So we got an initial month extension without too much trouble. Then there was a practical question of, well, do we ask for another month? Is that too much? Will they say no? Will they think we have a lot of nerve? We went ahead and asked for it, and they gave it to us without much trouble. So there's a lesson there. Ask for what you need, and often you'll get it. So we had until December 31st. We got some very helpful third-party interventions from Child Rights Connect and CRIN. This was a recently created procedure, so there was not a lot of precedent available to us. We started with a section titled Interest of the Intervener, in which we laid out the purpose and short history of INGOCGA. I mentioned our creation of the core report and our Canadian submission. We mentioned our areas of expertise and our goals of helping the committee. We next included a short introduction, a brief history of genital cutting and unequal treatment of male and female genital cutting, talked about growing recognition by the UN and other human rights bodies of intersex cutting, of female cutting, and of male cutting. We quoted Sarah Johnsdotter on the unjust double standard. Next, we included a word about religion, citing the 2012 Cologne case, giving human rights documents that recognize rights of freedom of religion, but clarify that one person's rights ended another person's body. We lay out the scope of the problem in the next section, with 650 million males living today after suffering genital cutting, along with 100 million females. We discussed complication rates and death rates. Next, we reviewed male foreskin anatomy and complications, and people probably don't typically know this stuff. We included some color photographs. We had to work with our team, which had quite divergent views on how much to say, how graphic to be, and we really tried to strive for a professional point of view. Antony and I were quite aligned on that, in fact, and there was quite a lot of behind-the-scenes work to come up with the most succinct, helpful document we could. We discussed analogies between fetal development of male and female genitalia. We discussed the functions of the foreskin. People don't know this stuff. Harms include trauma and pain, complications, harm to sexuality, emotional harm. Next, we reviewed the ethics, issues of consent. Ethical justification is hard to demonstrate. And we finished with a summary of leading human rights documents. Basic human rights principles say that you cannot ignore one violation because of other violations that may also be occurring. This is just basic human rights. Male genital cutting, we said, conflicts with each of the 4 core principles of medical ethics that Antony mentioned, autonomy, non-maleficence, beneficence, or benevolence, and justice. We concluded that male genital cutting provides no benefits sufficient to justify it under normal circumstances. Removing healthy tissue from non-consenting minors conflicts with widely accepted ethical norms, as well as with several convention and articles of the Convention on Civil and Political Rights. We recommended that the committee find the convention and other applicable human rights documents support a guilty finding against the defendants, the guilty finding that was in fact reached by the Finnish Supreme Court. Appendices include statements on male genital cutting from world medical associations and a map of male genital cutting prevalence. Even that map is different from what most people know. We've not yet received the CRC decision. We were in fact checking this morning to make sure it hadn't come out. And you know, it actually is a success that we had the honor of submitting a report, and I take that quite seriously. I feel it's a real step forward. I feel like the ferment of our differences actually made a stronger document. It actually brought us together. I'm ever so pleased to have been part of this process. It really is such a deep honor, and to stand here before all of you, and to work with Paul and Antony and the rest of our fine group. Lena was involved as well. It is exciting to be able to bring this issue to the UN's attention, 17 and a half short years after we first traveled to Geneva, and yet years that have been filled with growing attention to and concern with protecting all children, male children, female children, intersex children. I never dreamed I would be coming to Leeds and in a position to discuss this with such a level of progress, and I feel so blessed that protections of all children are growing and being extended, as we are all dreaming of, and I thank you all.